provide insights into the Senate's move to archive the impeachment complaint against Vice President Sara Duterte, we have retired Senior Associate Justice Antonio Carpio. Justice, good morning. Thank you for joining us.
Good morning. Good morning to our viewers.
Right.
All right, Justice, dami ng comments naglalabasan, but yesterday we also spoke to Attorney Monsod and he did say that he feels na may overreach ang Supreme Court. Do you, sir, share the same sentiment?
Yes, because, well, first of all, let's go to the glaring factual errors. No?
Right.
Sabi ng Korte Suprema that there was no plenary approval of the transmittal of the fourth complaint to the Senate. There was actually a plenary approval. And because of that, they have to reconsider, because that was the reason why they said the fourth complaint is unconstitutional, because there was no plenary approval. But there was. So they have to reconsider. Second, they retroactively applied the
Right.
new requirements. But on February 5, 2025, these new requirements did not exist. And the House approved the fourth complaint based on Francisco and Gutierrez rulings of the Supreme Court. It was in accordance with the decisions of the Supreme Court at the time. So now the Supreme Court is saying the action on February 5, 2025, even if it complied with our rulings, then is unconstitutional. Hindi pwede yan. You cannot retroact.
Right.
Because the rule is, if the new regulations will conflict with your decisions before, you must apply your new regulations prospectively.
Right.
That's right.
Because the House was not at fault. They just followed the Constitution.
Right.
They just followed the Supreme Court.
Yeah.
How can you fault them?
Oh, and we're talking
So
about
if you fault
two.
them,
Right.
that is violation of due process. Because due process means before you can be accountable for an action, you must have been informed of the law or the rule.
That's right.
Right. 'Cause-
And that information is either constructive or actual constructive, but if it is published in the official gazette, whether you read it or not, you're bound by that. Or if you are actually given notice, the law or regulation was handed down to you. But in this case, the new rules never existed. They couldn't have known it constructively or actually. So they cannot be bound by that. It will be very unfair
Right.
to retroact it. And that's why there is this doctrine of prospective overturning.
That's
right.
right.
Right. Oh, that's why.
Decisions of the
Oo.
Supreme Court should be prospective because if you give it effect, it will clash with your old doctrines, your old rulings. Ito yun. It should
right.
be given prospective effect. But ang posisyon namin sa isang bayan, you cannot even give it retroactive effect, a prospective effect, because it will practically kill the impeachment process. Because sinasabi nila, there should be a hearing at the plenary level. But at the plenary level, it says there, from the time you include the impeachment complaint in the order of business, you must refer it within 3 session days to the Committee on Justice.
Right.
Yes.
Right.
So you have only 3 session days. How can you have to notify the person being impeached? He will have to answer in writing and he will present witnesses, evidence. Hindi kaya
Hindi
within 3
kakayanin.
session days. So it's practically impossible to comply. Doon naman sa second mode, when at least 1/3 of the members of the House sign the articles of impeachment, sabi ng Constitution, the same shall constitute the articles of impeachment and trial by the Senate shall forthwith proceed. Walang time given to a hearing and
Yes.
in the House. Diretso sa Senate because that is where the hearing will be conducted sa trial. Now, if you require a hearing at the plenary level for the second mode of impeachment, how many days? you cannot exceed more than 3 session days. You have to be symmetrical with the first mode. But hindi rin kaya talaga 3 session days. And that was never the intention in the Estrada and Corona impeachments,
Yes.
which were direct filing by at least one-third. There was no hearing at the plenary level.
Oh, Justice, you raised so many good points po, no? But I want to also take on yung sinasabi po nila dun sa Supreme Court na they made specific 7 rules after this ruling at July 2025 ruling na sinasabi po nila dapat hindi nila ginawa yun because dapat po ang Supreme Court just interpret the laws. Tama po ba yun?
Well, tama yun because it's very clear. Under the second mode, nakalagay doon, once at least one-third of the members of the House signed a resolution on impeachment, nakalagay, and I quote, "The same shall constitute the articles of impeachment and trial by the Senate shall forthwith proceed."
That's right.
End of quote. So, there's nothing there. It's very simple. And that has been followed in the Corona and Estrada impeachments. They sent it directly. Walang hearing sa plenary, and even in the deliberations in the CONCOM, walang hearing. If you read it, it's very clear. Walang hearing. And the Filipino version of the Constitution says yung forthwith means agad-agad. So, agad-agad means wala nang hearing, diretso mo na, because that is where the hearing will be conducted in the Senate. Dahil, i-duplicate mo eh. The Senate will do that anyway. Why will you do it in the House? It's the trial shall be in the Senate.
Pero Justice, follow up ko lang po, no? Having said that po ba, magkakaroon po ba ng kumbaga pagbabago doon sa mga previous impeachment cases natin, yung isang attempt to kay former President Estrada and kay late Justice Corona?
Well, that's already settled. Tapos na yung term nila. Tapos ng term ni Estrada, and CJ Corona has died already. So physically it cannot be
But on the record.
it cannot be revived anymore. But theoretically, if you talk legally, dapat you also give them the benefit, no? That if you retroact this, void din yung impeachment nila.
Right.
That's right. Justice, no, also si Senator Tito Soto pointed out that one of the bases of the Supreme Court was probably a misunderstanding of adjournment from sine die adjournment. He pointed out in his interpellation and his speech that kala ng Supreme Court siguro when the adjournment was used on February 5, it was a sine die adjournment. Which it's not. In fact, it was just a regular adjournment na hindi dapat ma-terminate yung mga agenda nila.
That's correct.
Correct, Justice?
That's correct. It was not a sine die adjournment. So, nakalagay doon sa saligang batas from the time you include the impeachment in the order of business, you have 3 session days to refer it to the Committee on Justice.
Yes.
In-include nila on the 10th day. So within, sabi ng Supreme Court, that's still within the 10 session days. So they adjourned on that day. But since it's not sine die, there are still session days after that.
Yes.
Therefore, yung may 3 days pa sila to refer it to the Committee on Justice. So mali yung sinabi na when they adjourned on February 25, the one-year bar rule applied already. Hindi, because based on the Constitution, you still have 3 session days to submit it. So tama si Senator Soto. It was not a sine die adjournment.
All right. Let's talk about what happened at the Senate the other day, yung kanilang pag-archive ng impeachment case ni VP Sara Duterte. What's your reaction on that?
Well, the archiving means it's not dismissed. So if it is not dismissed, the Supreme Court cannot say the pending MR is academic or moot. And therefore, the Supreme Court cannot dismiss the pending MR based on mootness. That's the consequence. Dahil ang original position nila Marcoleta, the group of Marcoleta, was to dismiss.
Yes.
Right.
No? If it were dismissed,
Then that's dead.
the MR would have been dismissed also because moot na eh.
Yes.
Dinismiss na ng Senado. But since the Senate archived it only, the case in the Supreme Court, the MR, is still alive.
So okay lang po sa inyo yung ginawa nila, better than yung motion po ni Senator Dito Soto, which is to table.
Well, pareho naman yung effect. But that is definitely infinitely better than a dismissal.
All right.
Justice, I'd like to ask you about the comments of Senate President Escudero, who slammed most of the retired justices about saying parang it didn't please their narrative daw, kaya nagsasalita ngayon. Sa panahon daw ni Chief Justice Davide, most of them were against moving forward with the impeachment because of the same technicalities or issues that were hounding them today. Pero ngayon, when it suits, when it's a different name daw, Duterte ang nakalagay, biglang saying na dapat ituloy. Si Justice Ascuna has said, iba ang kwento, because sa panahon daw ni Davide, it's Committee on Justice dumaan daw doon. Dito was a different story. What are your thoughts on that?
Well, tama si Justice Adolf. Iba yung facts, no? That doon sa kay Davide, in the Francisco case, the plenary referred the impeachment complaint to the Committee on Justice. Umabot.
Okay.
So there was initiation,
Yes.
and the one-year bar applied. And after the one-year bar applied, dumating yung resolution ng House signed by 1/3. So barred na.
Okay.
All right.
Dito, ang nangyari, wala namang umabot sa Committee on Justice because this is a direct filing.
Yes.
Oo,
So iba. And that's why we are now in the Supreme Court. The Sambayan, of which I am chair, we filed a petition for intervention to precisely defend the ruling of the Supreme Court in Francisco and Gutierrez, na yun ang tama.
So yun nga po, you asked the SC to allow you to become a party to the case through a motion for intervention. How does this work? And yung pong inyo pong tanong din po sa Supreme Court to preserve yung status quo to prevent the Senate from taking concrete actions, yan po ay moot and academic na at this point. Tama po ba?
Again?
Apo. You ask for the Senate to preserve yung status quo along with your motion also to become a party to the case through a motion for intervention. How does this work po?
Well, the Senate already acted on the
Yes, so
archive, but it did not dismiss, so it's
Alright.
still okay.
Okay.
And our intervention has not yet been granted. We're waiting for the Supreme Court to act on it.
All right, with that, we would like to thank you on your time. Maraming salamat po. We hope we can still invite you again kasi I'm sure malaki-laki at mahaba-haba po itong usapin na ito. Thank you so much for your time and insights, retired Senior Associate
Thank you
Justice
also.
Antonio Carpio.